These are the notes for safety and legal considerations at a crime scene. So when it comes to safety, it's about keeping the investigator safe as they go into a crime scene that could have possible contaminants or diseases that they could get. So first, this has already been secured by the police officer that first was on the scene. So all of that is safe. So it's not in terms of like safety with the suspect. What we're talking about is like when there is blood or semen or saliva or other fluids that an investigator could come into contact with, they could contract AIDS or hepatitis B. Those are the two main ones that are possible. So to keep themselves safe, investigators always wear gloves. They will wear masks, a face shield, a full suit, depending on what they need. Some of you may have jobs where you have to do this, like if you're a lifeguard, for example. They call these bloodborne pathogens, so kind of diseases and things that would travel through any sort of bodily fluid. And you would wear any sort of personal protective equipment, PPE, as needed. So legal considerations. Evidence can be excluded from a trial due to unreasonable search and seizure. That means that if evidence is taken unlawfully, it will not be allowed to be in the trial. So if I'm the investigator and I just go into someone's house, they don't know that, I don't have a warrant, and I just take the gun that I see there, that would not be able to be in the trial. So in order to remove evidence from a person or a crime scene, it must be in conformity with the Fourth Amendment. So your Fourth Amendment states that there has to be probable cause supported by oath or affirmation describing the place to be searched and persons or things to be seized. So there needs to be a warrant. So a warrant is obtained through a judge. So detectives will go through a judge and they'll say, here's why we need a warrant, here's what we need it for and where we need it for. And they'll be very specific about like, is it the whole house? Is it one room? Is it just the car? Like, where can they look? And then the judge will issue that as needed. Or they might say like, you don't have enough probable cause. That person just kind of seems weird to you. Like you think they're lying. That's not enough to get a warrant. So there are times where it is allowed to do a search and collect evidence without a warrant, but it has to fit one of these. So it has to be like an emergency type situation. So let's say the police officers are outside the house the door is locked, but they hear someone screaming for help. They can break in. Anything they see that could be evidence. So that would be allowed. That would be like an emergency situation. If evidence was going to be destroyed. So let's say it was about to be burned in a fire. They could grab evidence in that case. Or it was about to rain and wreck the footprints. They could collect the evidence or the mold or the pictures or whatever before it was destroyed by rain. If the person is being put under lawful arrest. So for someone to be placed under arrest, there has to be enough evidence for that to happen in the first place. So if they're already under arrest, then they can be searched. So that's in the immediate control. So let's say someone gets pulled over, they run their plate, they say that there's a warrant out for their arrest, and they arrest them. That's a lawful arrest. They can search the person themselves, like maybe they have a gun in their waistband of their pants. They could also search probably their car that they're in at the time when they arrest them. And then last would be if the parties say you can search. So if the police officer comes to your door and they don't see any reason to come in, but if you allow them into your house and you say, come on in, you can search anything they find, that is allowable in court. Just like in your car, let's say the police pull you over if for speeding and they don't see anything in your car that is illegal, unless you say like, yeah, you can check in my trunk, or you allow them to look in the rest of your car, that would be illegal. Quick story, my cousin was driving, him and his friend drove to Colorado for spring break. And this was, 10 plus years ago or so. It was right after marijuana was legalized. And so my cousin and his buddy drove to Colorado, and it was funny because his parents told my parents, yeah, I don't know why they're going to Colorado for spring break. That's weird. And my parents thought, well, we know why, but okay. So they drove to Colorado. they got their weed, whatever, and they were driving back through Nebraska. And Nebraska, it is illegal to have marijuana. So they were pulled over and for speeding, and the cop saw, and I can't remember what it was, if it was prescription drugs, if it was some sort of paraphernalia for smoking weed. I can't remember exactly what it was, but they saw something which gave them probable cause to search the rest of the vehicle where they found the weed. My cousin and his buddy had to go to jail. My uncle and the mama of the other kid, they had to go down and bail him out. They had to go back down there for court, all that kind of stuff. So that was a probable cause situation. All right, so 2 cases to note. So 1978, it was Mincey versus the state of Arizona. It was a 4-day search at a homicide scene. So police raided the home of this guy, Rufus Mincey. He was suspected of dealing drugs. And there was an undercover police officer who forced his way into the apartment and was killed in the fight. So police searched the apartment for 4 days. They did not have a warrant at all any of the time. They found a whole bunch of stuff that would help convict, okay? And it was brought into evidence as a trial. However, when they appealed this, so he was convicted, but when they appealed it, so when they argue against it after the fact, they said that the evidence was gathered without a warrant, and he did not consent, and it did not fit any of those cases where it would be allowed without a warrant. And so the court agreed with Mincey that the police didn't have a right to search. So his appeal worked, and he got out, but he was later convicted on different evidence. So they had to go through this whole process again with other evidence instead of just getting a warrant the first time and doing it correctly the first time. Another case was Michigan, the state of Michigan versus Tyler. This was an arson case, so setting fire. So Lauren Tyler and his business partner, their business was destroyed by fire. Police couldn't search thoroughly because there was smoke, steam, it was dark, all that stuff. So the morning after the fire, they searched. Then they came back 4 days later to search again, 7 days later to search again, 25 days later to search again. They didn't have a warrant any of the times, and they took evidence every single time. So they were convicted, but the decision was overturned, just like in the last one, saying only the early morning one was legal. The rest were not legal searches. And the early morning one was legal because the stuff could have been ruined if it sat out there, like after the steam and the smoke. It could have damaged the stuff if they didn't collect it and preserve it. So that he was never convicted. And they believe the conviction was that he had done this for insurance purposes. So it is really, really important that if investigators can, that they get a warrant. Like those extra situations where it's legal without one, that's great, but you cannot bank on that. Like it's always important to get a warrant if at all possible. So that is the bottom line. When time and circumstances permit, a search warrant must be obtained before investigating and retrieving physical evidence at a crime scene. If at all possible, get a warrant so that everything is above board and legal. All right, so that is safety and legal considerations at a crime scene.